Welcome to The Briefing, a conversation with the experts and leaders about the ideas shaping American democracy. I'm Michael Waldman, president of the Brennan Center for Justice. We're having this conversation on January 6th, a portentous day, of course, in American history. But this is about breaking news, and we're hoping that the Constitution is not breaking at the same time. Over the weekend, as we all know, the United States took dramatic military action in Venezuela, and we're going to hear about the magnitude of it. And we're having this conversation now just a few blocks from the federal courthouse, where Nicolas Maduro, who was taken from Venezuela, is now under federal custody and facing federal trial. What are the implications of this? What are the legal rationales of this? What can Congress do to fulfill its role in war powers? Can presidents use the military this way whenever they feel like it for any reason? And what are the implications of that? We're going to have a rapid discussion on this breaking news with two of my colleagues. Liza Goitein is director of our Liberty and National Security Program. Katherine Ebright is an attorney with the Brennan Center and that program. Both are leading national experts on presidential power and these legal and constitutional issues. Thank you for being here with us. Why don't we start with the big question? What is different about this? The U.S. has engaged in military activity over the years. There's been a push and pull over the president's power to use the military and what Congress's role is. This feels very big and very different. What is different about this?
Under the Constitution, it is Congress, not the president, that has the power to decide when, where, and against whom the United States goes to war. At the same time, if the United States or if U.S. citizens come under military attack, the president doesn't have to wait for Congress. The president can defend the country or its citizens. This is the balance that the Constitution strikes. Over the last few decades, presidents have taken at times a very expansive view of this concept of defensive warfare, and that has led to the kind of push and pull that you've been talking about, Michael. The attacks on Saturday are a particularly egregious overreach in this area of claimed self-defense. That's at least one of the claims that the administration is making. And the idea here is that, we sent 150 military aircraft in the country, and then we had to bomb them because they were going to defend themselves against these military aircraft. And so we had to defend ourselves against their self-defense. And this kind of bootstrapping of self-defense is really, as I said, it's quite egregious, and it totally upsets the balance of power envisioned in the Constitution.
That has a legal implication in terms of whether this is unconstitutional, in terms of whether this is illegal. Katherine, you've looked at the history of how these military interventions have gone. In other instances, if you think about Afghanistan, the war on terror, the invasion of Iraq, as problematic as a lot of those turned out to be, there actually was congressional authorization for them. Isn't that right?
Yeah, so Congress, for both of our major Mideast wars in the past 2.5 decades, did in fact authorize the use of military force. So the war in Afghanistan was authorized in 2001 in response to the horrible 9/11 terrorist attacks. And then the Iraq war was subsequently authorized by the Congress in 2002. And that invasion, of course, happened in 2003 with the idea of ousting Saddam Hussein pursuant to a congressional debate and vote saying that the president could do that. And so that sets this operation very much apart from the Mideast wars that we saw, the regime change war in Iraq that we saw in the early 2000s. Also, sort of circle back to Liza's response, how is this different? To the extent that the administration is trying to advance a self-defense claim, it is novel, it is absurd. But I think that there's a little bit more going on here. That is one very, very thin reed that they're advancing, one argument. but they're saying a whole bunch of different things. And I think, you have different actors within the administration advancing different ideas for why maybe this was lawful. So one is this is entirely law enforcement, which obviously it's not law enforcement if you're entering a foreign sovereign nation and then dropping bombs on 5 locations using 150 aircraft and capturing through boots on the ground their head of state.
Well, and to remind folks, there is a federal indictment of Nicolas Maduro, but it is a superseding indictment for an indictment that goes back years in federal court. So there was not an imminent legal threat even there at the same time. They've said they've flipped and flopped around. They can't quite get their rationales straight. Even in that epic press conference, they didn't articulate one particular rationale. Of course, President Trump kept landing on the idea that this was for oil. But it is our understanding, and Senator Schumer has said this, that in the weeks leading up to this, the administration explicitly told Congress this was not an attempt at regime change. So have they landed on an argument as to why they did this?
Again, I think there are different actors within the administration saying different things. Trump has really hammered the they stole our oil, we need the oil back argument. Marco Rubio has talked about how Maduro was harming U.S. citizens through this very circuitous path of point-to-point gang violence and then narcotics trafficking. But that is so attenuated, it in no way rises to the level of an armed attack or imminent threat that would actually trigger the president's war powers. And the last thing that I'll say on that is it really does echo the president's invocation of a wartime law called the Alien Enemies Act back in March, which he used to round up Venezuelan immigrants and then try to deport them to really horrible places like the notorious prison in El Salvador, Secat. And the courts have held up that invocation, saying Venezuela did not, in fact, invade or do this other kind of attack against the United States. And so it really pulls the rug out from under that self-defense argument.
And Liza, you've made the point that on these war powers issues, the courts usually try to stay out of things. And whether that's good or not, that is, as you've pointed out, what usually happens. But here the courts have actually said, by the way, we're not at war with Venezuela, and we're not under attack from Venezuela.
Right, and that's an unusual situation because it did come up first in this domestic context where the president was basically abusing war powers to try to deport Venezuelans who were suspected of being part of a criminal gang. And because it came up in this domestic context, the courts actually did look at whether we were under invasion or whether there had been an incursion by Venezuela. And as Katherine said, the courts have rejected this pretty much out of hand. So that certainly does transfer over to the extent that the rationale here, and again, there's a lot of different rationales we've heard, but to the extent the rationale is self-defense against some kind of invasion or incursion by Venezuela, the courts have already said that that isn't happening.
And Katherine, quickly, I want to ask you about a piece you're going to be publishing today on the Brennan Center website about what looks to the naked eye like an analogous situation, which was the U.S. military action in December 1989 in Panama, where eventually we seized the president of that country, and Noriega actually spent time in federal prison because he too had been indicted. But you've looked at it and it really is a little different, you would argue.
I'd say it's a lot different, Michael. So a number of administration officials have cited the Panama supposed precedent. And so the facts of that, as you said, 1989, the H.W. Bush administration deploys roughly 30,000 U.S. troops to invade Panama, depose General Noriega, and install a more favorable to the United States regime. And so again, on its face, that looks not unlike what we just saw. It is very different though, because as Liza said, the president does have this inherent authority to act in defense of the nation and U.S. citizens, U.S. forces abroad, even before Congress has voted in favor of using force. The president can forestall those kinds of imminent attacks or imminent threats to these persons or U.S. territory. Of course, that is supposed to be a power that's used proportionate to the threat. And what happened in Panama in 1989 was 5 days before Bush's invasion of the country, the legislature of that country had actually declared a state of war against the United States. And General Noriega had given an extremely bellicose speech about the United States. In the days following that declaration of the state of war, there was the harassment of U.S. Marines, U.S. citizens who were in Panama. Under the Panama Canal treaties, we actually had the right to operate a number of U.S. military facilities within Panama. And so there had just been, in the past several years, even preceding that declaration of a state of war, an escalating series of incursions onto those military facilities that then came to this sort of fever pitch in December of 1989. Now, is sending roughly 30,000 troops into a country, deposing its leader, proportionate to the immediate threat that was faced by U.S. citizens who were in the country? Very few people think that it actually was proportionate, but there was this genuine core of concern and self-defense prerogative that the president could have executed in that circumstance. And the other thing that I'll say on this is Congress actually had debated for a while what to do about those escalating tensions with the Noriega regime. And the Senate had, before going out on recess, adopted non-binding language. So it's not a formal authorization for use of force. It doesn't mean that what H.W. Bush did was legal. Had adopted non-binding language encouraging the president to consider military operations for deposing Noriega.
And they said very explicitly, as I understand, and as you've written, they said, oh, this was not about the indictment. This was about the declaration of war, the threats to military personnel. American soldiers had been killed, and all those other things. They at that time said, oh no, this is not just about the indictment. So they did not say that the indictment gave them legal authority to invade a foreign country. They said that the declaration of war, the threat to the U.S. citizens and U.S. service members, and our treaty right under the Panama Canal treaties to defend the Panama Canal Zone, that was what allowed them to do this action, which, again, generally speaking, we understand as an unlawful act, not something that was establishing some uniform precedent that forever changed the separation of powers between Congress and the president. And within a year or so, when we launched the Gulf War to retake Kuwait from Iraq, President Bush then did go to Congress to get an authorization that was a much more sustained and bigger military operation. But it actually launched a pattern post-Cold War where there have been a number of these efforts to go to Congress. Liza, let's turn to that and what Congress's role is, because if the courts are not likely to step up here, Congress emphatically has the constitutional duty to play its role. What can Congress do, and can both of you, starting with you, explain to folks what the War Powers Act is, what the War Powers Resolutions are?
Sure. The War Powers Act, well, this was obviously in the context of the Vietnam War and, in fact, and hostilities that had gone far beyond anything that Congress contemplated or even knew about in terms of the bombings in Cambodia, et cetera. And so this was an attempt for Congress to reclaim and reassert its own powers over when the president goes to war, which, again, the Constitution gives Congress that authority. And basically, it requires the president to report to Congress when hostilities have been undertaken overseas. And then there's a certain period of time, 60 days is the default period, after which the hostilities must cease if Congress hasn't approved them. In addition, Congress can pass a resolution at any time under expedited procedures to terminate hostilities that are unauthorized or that Congress believes to be unauthorized. And so certainly under that law, Congress could at this point pass a resolution to terminate and to prevent any future military action in Venezuela. And there are resolutions that are pending in Congress to that effect. And I'll turn it over to Katherine to say a little bit more about those.
Yeah, I think one thing worth noting too about that 60-day period or 60-day clock that you mentioned, Liza, is that that is contemplating the president's need to engage in self-defense, right? It's not saying the president has a blank check to use force for 60 days wherever he would like. It is sometimes the president, even without Congress, needs to act in defense of U.S. territory or U.S. life abroad. And we need to accommodate that within the structure of the War Powers Resolution and saying, instead of saying blanket, the president just cannot act ever unless it is authorized by the Congress. That has been sort of taken out of context. The 60-day clock has been taken out of context by people who want to assert very, very broad presidential powers off of the War Powers Resolution, sort of flipping that law on its head. In this context, we have seen a number of War Powers Resolutions, these expedited mechanisms to force the president to withdraw U.S. forces from hostilities, be introduced by lawmakers on a bipartisan basis. And so this week, there's going to be a vote on a War Powers Resolution introduced by Senators Paul and Kaine that would force the president to refrain from further hostilities in Venezuela. That's very relevant because Donald Trump has not only done this exceptional action with the bombing and then regime change operation targeting Maduro, but he's also said that he plans to, quote unquote, run Venezuela, and that he is open to doing more ground operations, open to doing a second wave of bombings if Venezuela doesn't, engage in a way that he would like, which, as he said multiple times, means giving the U.S. access to oil. And so the threat of further hostilities is very real. Additionally, Trump has said that there's a blockade. That's also generally been understood as an act of war. When you are using your Navy to prevent vessels from a foreign country to transit the sea in a freedom of navigation capacity. And so there are certainly hostilities or the threat of imminent hostilities that are still present. And so the War Powers Resolution from Kaine and Paul would sort of tamp that down and reassert Congress's will and say, this isn't really defensive. You don't have the authority to do this and it needs to stop.
So to remind folks, Rand Paul is a Republican, Tim Kaine is a Democrat. Liza, Secretary of State Marco Rubio, who now apparently has been put in charge of this country as well as many other jobs he's been given every time President Trump illegally fires someone, he puts Rubio in charge. He has said, the War Powers Act does not apply here because there are not ongoing hostilities. There is not an ongoing war. There is not an ongoing occupation, notwithstanding us saying we own, we run the country. Why is that wrong?
Well, he's also said we're leaving the Armada in place so that we can use the Armada if we need to. And President Trump has, as Katherine said, threatened to use military force to have a second wave if necessary. And they have the military surrounding Venezuela and poised to act. And in that situation, the War Powers Resolution is certainly triggered.
And so that's going to happen later this week. And again, there's the bringing up of the War Powers Resolution. It's called a privileged motion, I believe, which means it's hard to stop it from being voted on. But the key is that what happens if it's voted on and it's voted down? In other words, there was a resolution voted down in the House of Representatives. What are the implications of that?
That's still not approval. You would still have the part of the law. So the law allows a resolution to terminate hostilities, but the law also requires hostilities to stop after 60 days if Congress has not affirmatively approved them. And as long as Congress fails to do that, after that period of time, that 60-day period, then hostilities must end, even if Congress has not affirmatively passed a resolution terminating the hostilities.
And very briefly, do courts, let's talk about the implications of this for presidential power, for war powers. Do the courts then step in and say, well, you know, the clock has run out? Or is this something where we really can't expect the courts to be the prime movers so much as Congress and the public?
I'll let Katherine answer that. Yeah.
I think it's unlikely that we're going to see the courts as the prime movers if Congress fails to act. The courts have something called the political question doctrine, where if there's a thorny political dispute where they feel like maybe it falls outside our expertise, the courts say that's actually a matter for Congress and the president to sort out. It's not for us to step in and insert our will. And so I think if there is no competing resolution that the White House ignores, we are unlikely to see this go to the courts and then have the courts step in and say, you can't continue to occupy Venezuela, or these rounds of strikes are unlawful. There are a small number of ways that you can get war powers questions before the courts. But as Liza noted, in the context of the Alien Enemies Act invocation and that litigation, it typically happens when there are U.S. domestic equities. And so we will see further answers from the courts on, did Venezuela invade us? Are we under threat from Venezuela in the context of the Alien Enemies Act litigation, where they're targeting immigrants stateside? But again, I think in terms of, is it lawful for Trump to undertake these actions abroad, it's a little bit less likely.
And of course, the courts have stepped up in a number of different ways on the use of the military domestically. We've been part of that litigation in a variety of ways, and just recently, the use of the National Guard in Illinois, for example, was blocked by the federal courts, and then the White House announced it was pulling back from other places. Liza, in his free association press conference on Saturday, the president's mind went to the domestic deployment of the military. What is the implication of all of this for presidential power, for the use of the military, and broadly for the constitutional order? And I'll ask you each to sum up what you see the big implications here as being.
Sure. I think there are some similarities there, in the sense that this president, likes to use the military to accomplish his policy priorities, whatever they may be. They're somewhat mysterious, maybe, in Venezuela. And he, is willing to do that even when the law tells him that he can't. And in terms of Venezuela, the operative law is the Constitution, under which, again, Congress has to authorize any offensive military operations. Domestically, the relevant law is the Posse Comitatus Act, which generally prohibits federal armed forces from engaging in law enforcement activities unless there is an express statutory authorization. So he has been willing to cast aside the Constitution and the rule of law in order to use the military as a tool to get done what he wants to get done. That's incredibly dangerous. Because the rule of law, separation of powers, these have consequences for everything that happens in this country in terms of our democracy and in terms of our individual liberties. The separation of powers in the context of Venezuela, that is not some kind of technocratic feature of the Constitution. It is a core protection for our system of government and for our freedoms, for our democracy. And so even though the immediate victims of Saturday's actions in Venezuela may be Maduro and his wife, perhaps in the somewhat longer term, perhaps the Venezuelan people and U.S. service members, depending on how this plays out, eventually the consequences of this kind of disregard for the separation of powers will be felt by all of us in this country. So it's really important to see the bigger picture here.
And Katherine, quickly, what do you want to leave folks thinking about?
There's the degradation of rule of law at home, the degradation of our constitutional protections. International law is not the focus of the Brennan Center, but I think it's an important thing to think about, the degradation of our international rule of law and how we're contributing to that when our own safeguards at home fall short. And so I think this action puts us into a more dangerous world, a more uncertain country, a more uncertain region. And there are reasons that the founding generation took that care with the Constitution to separate the war power between the president and the Congress, where the president only gets to do self-defense when there's this threat to US territory or life, and the Congress otherwise has to debate in a really deliberate and accountable way when we're using the military to do these kinds of exceptional actions. And so that's a very important balance of power, and it makes us less safe to live in a world where that's not respected.
On this, as on so many other issues of presidential abuse of power, judicial overreaching, Congress has to play its role. It's Congress's abdication of the role the Constitution and our democracy assigns it that leaves presidents, this president, the room to abuse power and to do the kinds of things we've seen. During that press conference, the only real attempt to make a legal justification from the president was when he referred to what he said was the iron law, which seemed to be might makes right, which seemed perhaps to be we get to run our hemisphere, and the implication being maybe Putin gets to run Europe and Xi gets to run Asia. It is not the system built by the United States over many decades with allies after World War II of international law and international institutions which has kept us safe and which has preserved the peace in many ways. There are big implications here of this breakdown of law in the United States for the stability of the world. We're going to continue to focus on our own Constitution, our own law, and a lot will happen over the coming days and weeks. We will be part of this conversation. Thank you to Liza Goitein and Katherine Ebright for educating us and for continuing to push for what we all care about. If you have enjoyed this Rush edition of The Briefing, please share it with others. Please subscribe on the social media platforms, and we will be back again in coming weeks.